Good morning, everyone. My name is Chris Morgan. I'm an attorney at Barron Liebman up in Portland. Here today to talk a little bit about what reopening your business is going to look like, key considerations for employers, both with respect to timing, safety concerns, sanitation concerns, what I need to do logistically and from an administrative standpoint to get things up and going again as quickly and as safely as possible. So hoping to jump through a bunch of different content today that hopefully you're going to find useful. And with that, we'll just jump right in. So the biggest question, and luckily we finally got some definitive guidance and guidelines on this as of yesterday, were what exactly is the timing going to look like for us to enter what the state is calling phase one. We have sort of phase one, phase two, phase three. These things are going to look a little bit different across different industries and with respect to different physical spaces and all of that sort of thing. So we're going to cover quite a bit of that today as well, sort of what you need to do to be prepared in order to open your doors. But finally, we got definitive guidance on sort of what are the 7 criteria that any given county needs to meet in order to enter this phase one. And there's a list of industries and different businesses that are going to be able to open as part of this phase one, but the very first prerequisite, and as we're calling these gating requirements, you may have heard this sort of at the federal level as well, we're thinking of them as, okay, the coming through the gate, the very first things that need to be completed in order for us to do anything else, these requirements need to be met. And so as you can see here up on the screen, we have sort of 7 different pieces. A declining prevalence of COVID-19, minimum testing regimens, a contact tracing system, and just sort of for reference, contact tracing is something that's really been around for a long time. It's not as popular here as it is in other places, but essentially what it means is that we have a person who tests positive for COVID-19 in any given place, someone who is a designated contact tracer from the Oregon Health Authority or elsewhere. State's actually hiring a number of contact tracers on a contract basis as we speak. What those folks then do is interview the person who tested positive and then figure out sort of where they've been, who they've been in contact with, etc., so that they can then contact those folks to see if they're exhibiting symptoms, if they may need to self-isolate or self-quarantine for a period of time, etc. And the idea is by sort of getting into touch with these folks who have been in contact in some sort of physical space or physical environment with someone who has tested positive, we can learn more about sort of the underlying virus itself, as well as make sure that we're making safe, smart decisions about potentially isolating those people if indeed they are exhibiting symptoms. Next, what the state's looking at are isolation facilities. And so what this means are things like hotels or other quarantine centers for people who might be exhibiting symptoms but do not otherwise have a place to go. So think of homeless people, for example. Do we have hotels that may be empty or quarantine facilities that we can take these folks in the event that they're not able to self-isolate or self-quarantine in a home environment? Next are the industry-specific standards. So these are going to be probably the biggest thing that companies are going to have to look at an individual basis, because they are specific to exactly what you do, what your physical space looks like in terms of square footage, what sort of physical distancing you can potentially implement within that space, etc. So there's going to be different guidelines for restaurants, for example, or for retail, or for salons and barbershops, things like that. Once those are solidified, which we're very close to having those solidified, companies are going to be able to take that guidance and implement it at a county by county level, essentially. We'll talk a little bit more about that in a minute. Finally, the last 2 prongs are sufficient healthcare capacity, and then sufficient personal protective equipment supply, so PPE. We talk about this quite a bit. And so what this is going to look like essentially are that hospitals are going to have to make certifications to the state with respect to their healthcare capacity. A certain percentage essentially needs to be reserved so that folks are able to take on any surge capacity that they may need in the event of an outbreak, etc. And then you're going to have to also certify to the state that you have an adequate amount of personal protective equipment. That's going to look different for hospitals in rural areas than it will in places like Portland, for example. They're different standards. So with that said, these are the 7 gating requirements. Now, there's nothing really you as a supervisor, a manager, or business owner can do right now with respect to getting your county across the finish line here in order to get into phase 1. What's happening is that as of May 8th, counties, individual counties, are able to submit an application to the state saying, hey, we meet these 7 criteria. We have the industry-specific standards that we need for businesses that are located in our region. We have a declining prevalence of COVID-19. We have a testing regimen in place that's able to test a sufficient number of people based upon our population. We have a contact tracing system in place, which the state is helping with. We have, adequate healthcare capacity. We have sufficient PPE, all of that stuff. Those are proposals that are going to be submitted by the counties and then approved or not approved at the state level. So nothing specifically really that you can do, but to be on the lookout for the individual county that you're located in submitting that proposal, hopefully as soon as possible, to the state for approval. Now, we also received additional guidance yesterday on what exactly can open in phase 1. And to be honest with you, it's more broad than I thought initially it might be, and that a lot of us thought initially it might be. So here's sort of what we're looking at. Childcare facilities, retail stores, summer schools, summer camps, youth programs, restaurants and bars, personal care facilities, that includes gyms and fitness centers, salons, barbershops, massage therapy, all of that stuff, and even local gatherings up to a maximum of 25 people. Here's the catch though, right? So all of these people are going to be able, all these facilities are going to be able to open. However, you also have to meet these industry-specific standards that are specific to your business, right? So all of this and the ability to reopen is contingent upon your individual business being able to meet the industry-specific guidelines for your business. So retail has industry-specific guidance. Bars and restaurants have industry-specific guidance. Some of the things that are contained within that industry-specific guidance are things such as, at restaurants are going to have tables that are going to have to be 6 feet or more apart. So as we'll talk about a little bit more later, reconfiguring physical spaces is going to be a big part of this. Having a sanitation plan in place, which we're going to talk about as well, is also going to be important. Having a employee safety plan in place, which is again something that we're going to talk about here in a little bit. These are all part of these industry-specific guidelines that you have to meet at a personal level. So think about sort of these 7 gating criteria that the county has to use in order to apply for approval by the state. Those are things that are sort of at this juncture somewhat out of your control. But these industry-specific standards are specific to your business, and these are things that you need to look at and start implementing as soon as possible, right? Because as soon as your county gets approval, you want to be able to open your doors, have customers come in, and start getting the ball rolling on that stuff again. So I encourage everyone to look at the industry-specific guidance. If we went through the industry-specific guidance for any and every industry, we'd be here an extremely long time, but they're fairly clear and concise. It provides guidelines on different physical requirements, and then, to be honest with you, there's some arbitrary stuff that's in there as well. For example, restaurants and bars at this point are not going to be allowed to serve after 10 p.m. Why? I have no idea, but it's in there, and we want to make sure that in order to be able to reopen, we can prove that we have a plan to meet these industry-specific guidelines. So, what exactly does that mean in conclusion before we sort of get to some of the more specific things that you can do in terms of a sanitation plan, employee safety plan, from an administrative standpoint, etc., in order to get reopened and get the ball rolling? What questions should I be asking myself in finality about when can my business reopen, right? One, it depends on those 7 gating criteria that we talked about and whether the county gets approval. So these are the 3 questions I sort of want you to ask, because at the end of the day, the consequences for reopening without having met these requirements are sort of twofold. One, the state has the ability to come in and shut your operation down, which we obviously don't want. No one wants that. And second, you run the risk of OSHA violations. We'll talk a little bit more about OSHA later on down the road. But in terms of complaints brought either by employees or independent third parties or the state themselves to come in and say, hey, you're not meeting these industry-specific standards, and we have an issue, and all of a sudden then you have OSHA complaints on your hands that also we want to avoid, right? So these are the 3 questions I would have you ask, right? Has the county that I'm located in applied and been approved to enter phase 1? Now, it's quite possible that a number of you have locations or operations in several different counties, right? And so it may be specific to that. If I have a barbershop that can open in Medford, and I have another barbershop that I own that's in Portland, it may be different, right? I may get approval for one before I get approval for the other. So make sure that based upon the physical location of the business, that's what we're looking at in terms of sort of that county application and approval process. Second, have I met the industry-specific requirements for my business, right? If I have a retail establishment, if I have a restaurant, if I have a bar, have I gone down sort of the checklist of industry-specific requirements, which are provided on the state's website, and said, hey, I can check these boxes, right? I've done this, I have a plan in place, we're working on it, etc. And as we're going to talk about here in a little bit, we're going to want to know, the state's going to want to know at some point that you're taking affirmative steps to get these things done, and we want to put you or help put you in a position that if there ever were any questions from OSHA or the state about whether or not you're following the rules, that yes, we have a written plan in place, right? So that's number 3 here. Do I have an adequate plan in place? And that's going to be the sanitation plan that we're going to talk about. That's going to be the employee safety plan. It's going to be from an administrative standpoint. Do I have a plan in place to bring folks back? And am I doing what I need to do from a Form I-9 standpoint and all of that? Do I know what my requirements are with respect to sick leave, etc.? And, have I updated my telework policies, my accommodation policies, and all of those things that really go into this more holistic picture of getting your business up and running again? So with that said, what we've just talked about are these gating requirements, out of our hands to some extent, right? But we have to start planning for reopening right now, because my goal for everyone, and especially as a business advocate and as an employment attorney, I want to see businesses thrive and I want to see them do well. And I want to put people in a position to be able to get up and running as soon as possible. So right now we're going to jump into sort of some of these things that are in your control that we can get moving on right away. Let's get into a couple of things. I broke these out into different policies because I think they really are 2 separate things. And we're going to talk about a sanitation plan, an employee safety plan, and then what internal policies that I need to draft or create in order to make this work. So first, I want to talk about a sanitation plan. What I anticipate the state is going to require for each business, and if not require, strongly recommend, and really, to be honest, it's a good guideline for anyone to have. If you don't have a sanitation plan, in place for your business, you should create one and it should be in writing, right? And two things to think about there, right? One, we want to have a safety and sanitation plan in place for the good of our employees, but also from a legal risk and mitigation of risks standpoint, we want to have a written policy in place that says, hey, here are the proactive steps that we're taking to protect both our employees and our customers. And this is going to be dependent upon your individual workspace. So there's not going to be a one size fits all for everyone. But the best thing that we can do is to follow CDC guidance, and sort of just a little vignette on why we say this. One, the CDC is supposed to be the leading authority on sanitation, right? So at the very least, if we are creating a plan, we want to be able to say, hey, we created this plan based upon CDC guidance, and to the extent that the state, for example, says that this plan isn't comprehensive enough or it's not acceptable, we can say, hey, we base this upon CDC guidance. There was a leading authority that served as the basis for the drafting and implementation of this policy. So use CDC guidance as the basis of the sanitation policy, which you're going to draft, make it a written document, make sure that it's distributed to employees, including managers, supervisors, all the people that are going to implement this, right? And what we're really talking about here are enhanced cleaning and sanitation procedures for high-touch areas, right? We're talking about doorknobs, walls. Think about all of the different places in your individual workspace that we would consider to be high-contact areas. Kitchens are high-contact areas. Doorknobs, again, bathrooms. What are some extra sanitation procedures that you can put in place to ensure that those things are being cleaned in a manner that is greater than whatever you were doing before? It's possible, of course, that you had a great sanitation procedure already put in place, but if not, if you don't have one at all, you need to create one. There's always room for improvement, right? We want to say we're taking these steps. Again, based on the CDC guidance, we're taking these additional steps. Okay, it also likely is going to involve sanitation equipment, hand sanitizer, potentially providing gloves, potentially providing wipes for touch areas within people's own individual workspaces. So keyboards, for example, are there wipes for the keyboards? Are there wipes for the screens? To the extent that you can provide these things, you should be providing them, right? And again, this is all about trying to keep both our employees safe, anybody that may come into our establishment safe, but also having a plan in place, and this goes to our overarching theme of reopening, right? Having a definitive sanitation plan in place that we can go to the state with and say, look, here's what we're going to do to keep people safe. We've thought about this. We're not just opening our doors and going full steam ahead without critically thinking about some of these things. We've thought about it. Here's our written plan. We've distributed this to the people who need to know. And that's going to be extremely beneficial, and it's going to help folks open sooner, I can guarantee it. Okay, on the same plane, but separately from a sanitation plan, we are recommending that people draft and implement what we're calling an employee safety plan. And that, again, is going to look different for different employers depending on the amount of employees you have, the workspace, how it's physically set up, and all of these other things, right? But we want to have a plan in place for employee safety specifically, because one of the issues that's going to come up, and we're going to talk more in depth about this later, is what do we do in a situation where, okay, we have to go ahead to reopen, but an employee doesn't want to come back on the basis that they don't feel safe, right? What are the steps that we are taking to show our employees, aside from sanitation, right, that one, we put their, health and safety first, but two, that they should know that we are taking steps with other employees to ensure that they necessarily, don't necessarily have to interact with certain folks or come into contact with other people. There's a whole lot of different things you can do, right? But you should come up with an employee safety plan specifically tailored to your employees and to your business that ensures that people feel better about coming back to work. Okay? So here are a couple of recommendations. And some of these things, I have to admit, if you told me 3 months ago that employers were going to be able to do these things, like temperature checking, for example, I would have said absolutely no way, under what circumstance would this be allowable under the law, but now it is. And it's not to say that you have to implement all of these measures, but these are things that we're recommending that are going to be legal procedures that you can put in place as part of this employee safety plan. Okay, the first, and we're working on finalizing a form for this right now that will hopefully be available to you all, is an employee authorization form. Essentially, what this does is, one, it serves the employees and makes them feel more safe that the company is monitoring folks as they're coming in and out of the office or workspace. They're literally authorization forms in which, when people come in to the office, they certify that they're not exhibiting flu or COVID-like symptoms, that they haven't been around someone who's tested positive for COVID-19 within a certain period of time, and that they're willing to submit to a temperature check, for example, if they're not feeling well. So these are things that you can do. So I come into the office, I certify that I'm not exhibiting symptoms and that I haven't been around folks that are exhibiting symptoms. And I certify that and I keep it on record. This is going to help, one, with contact tracing, but two, in my ability as an employer to feel better about the folks that are coming into the office. But also, very importantly, that the employees know that we are sort of tracking and monitoring folks who aren't feeling well, and then we're not putting them in a position where John comes into the office and he's got 102-degree fever and he can't certify that he's feeling well, that we're not keeping him there, right? We are sending him home, asking him to quarantine, asking him to work from home, etc. Second piece of this, I'm not going to recommend this to anyone and everyone, because I totally understand that to some it sounds absolutely ridiculous and outlandish that I would ask my employees to take a temperature check. But I want to let you know that it's an available option and could potentially be part of your employee safety plan, right? You're able to take employees' temperatures or ask them to take a temperature check in the office. Really what we're looking for when they're coming in is, are they 100.4 above or below? Now, a question that comes along with this is, if I have an employee that's not feeling well, I have an employee that comes in and they test at 102 degrees, for example, can I send them home? And the answer is yes. The answer is yes. I think some of the law, particularly in the last 6 to 8 weeks, has changed around, are we doing what's best in the best interest of the employee, or are we doing what's in the best interest of the larger group in terms of accommodations and a number of other things? But essentially what the law has now done is said, yeah, we can send you home. If you're not feeling well, if you're testing over a certain temperature where we feel that you're potentially putting other folks in the office at risk if you stay here, we are able to send you home, right? We're talking about employee isolation and monitoring. So do we have a plan in place where if an employee comes in and they can't certify, for example, that they're feeling well, that they don't have a temperature, that they don't have a cough, and if they're testing, for example, over 100.4, do we have a policy in place where we can send that person home, move them to remote work if possible, and then stay in contact with them to make sure, one, that they're staying on track with their work, but two, that they're feeling okay and that they're getting appropriate care if they need it, right? Again, two ideas within this whole thing. One, we care about the health and safety of both employees and the customers that come through our door. But two, do we have a plan in place from a legal standpoint, right, that says, here are the steps that we're taking in such a scenario where someone isn't feeling well and where they may otherwise be putting someone at risk. And this is important for the contact tracing as well. It's sort of the same idea. Next step in this employee safety plan, right? And all of this is non-exhaustive, right? There's some ideas that we're talking about here that can be included in this employee safety plan, but it's not exhaustive. You can include anything and everything, really, so long as it's within the bounds of the law that you feel would fit your particular work environment, the amount of employees that you have, etc. One thing that's going to be applicable to everyone, though, is ADA compliance, right? Am I making reasonable accommodations? Am I making physical accommodations in the workplace that otherwise allow me to be in line with my obligations under the Americans with Disabilities Act, right? So, for example, if I have an employee that says, hey, I really don't feel safe coming in to work based upon the proximity of my desk to other folks in the workplace. Are there accommodations? And this is sort of absent of whether or not this person has a disability that would otherwise qualify under the ADA. It's really the same analysis, right? This accommodation analysis, I really want people to think, absent some of the other standards under the ADA, is there a reasonable accommodation that I can make for an employee under the circumstances to make them feel more safe? Okay, so if that, again, for example, is someone saying, hey, my desk is too close in proximity to another individual, I want the employers to think, is there a reasonable accommodation that I can make under the circumstances to make that person feel better and to make them feel more safe? There may not be, right? There may not be, but I want employers to make sure that they're going through that process to see, are there different adjustments to physical space, which we'll talk about in a minute a little bit more, adjustments to physical space, to work environment. Is there the ability to allow this person to work from home? These are all things that we should be thinking about, and it really, at the end of the day, is this sort of ADA analysis. Without it being an undue burden to my workplace, are there accommodations that I can make to ensure the safety of employees? And I think that's an important part of this employee safety plan that, again, can't say it enough, it should be in writing, and it should be distributed to employees and should have it ready to present to folks at the state as well if they ever were to ask for it. So who creates this? And this is going to be different for every business. But what we're recommending, because it can be a lot of work for just one individual, right, is to establish, to the extent that you can, a team, work group, or task force that can work through some of these things. That's the sanitation plan and the employee safety plan, right? So this could be someone that's in HR, for example. It could be a manager. It could be a CEO. If you're in a small business, a family-owned business, maybe you're all doing it together internally. As many heads as you can get in the room to think about these things really is beneficial. My philosophy is that, it's not a good situation when there's one person that's always making any and every decision, right? We want to have a collaborative environment, and it's a productive environment that we want to foster anyways, right? But to the extent that we can get as many people involved as possible to sort of brainstorm what are some things that we should be concerned about from a sanitation and a health and safety standpoint, and how can we codify that into a written document is good. And I would encourage people, honestly, to solicit feedback to the extent you can from employees and ask them, what are some modifications to your personal space within our work environment that could, potentially help you in your return to the office? Soliciting employee feedback is beneficial in any environment, but I think particularly right now, where folks are going to have the choice, at least for the time being, to decide, hey, am I okay coming back to the office, or do I want to stay home for longer? Right, soliciting their feedback on what would make them feel more safe and more comfortable is absolutely 100% the recommendation. We want to gather feedback, think about these things critically, and then we want to codify it in a couple documents. One, a sanitation plan. Two, an employee safety plan. And we want to go from there. Okay, a couple of notes real quick that I want to touch on with respect to reconfiguring physical workspaces, because this really is dependent upon, as much of this is, the size of your business, the amount of employees that you have. Maybe you have half of the folks that can work from home, but you need the other half to be coming into the office. It's really not a one-size-fits-all for everyone. But one thing that I can tell you 100% is here to stay, at least for the foreseeable future, is this idea of social distancing, physical distancing, whatever you want to call it. That is going to be an overarching idea moving forward. I can guarantee that whatever final industry-specific guidelines are released are going to include things like you can have as many people in your store or in your restaurant as you can fit, so long as you can otherwise abide by physical distancing, social distancing restrictions, right? And that's this idea of being 6 feet away, etc. And again, however you feel about it, it is what it is, and I can tell you it's probably here to stay for a while. So how can I reconfigure physical workspaces to ensure this idea of physical distancing, right? It may be moving people's desks farther apart. It may be some sort of plexiglass, for example, that goes up at the front of the receptionist's desk to ensure that they're not sort of face-to-face with people more than they need to. There's a number of things that you can do in terms of getting creative, and again, it's specific to your own workspace and own work environment to ensure this physical distancing. It's not going to be an issue for everyone. If I'm working, for example, on a farm property and we have 5 or 6 employees out there that can easily maintain physical distancing from each other, this isn't going to be an issue. It's really going to be an issue for people that are tied via a lease or a building, for example, to a certain amount of square footage and having to figure out, okay, how can I accommodate the folks I want to accommodate, customers, while still maintaining this idea of social distancing. And that's going to be things like, for example, making sure that tables at a restaurant are at least 6 feet apart. From what I'm understanding from the restaurant guidance that's been released so far, there may be a limit on the amount of people that can sit at a single table, but those folks wouldn't necessarily have to maintain, of course, physical distancing from each other, so long as they're choosing voluntarily to be there with each other. But things like moving tables, moving chairs, it's going to be different for every workplace, but you do want to have this reconfiguration of physical workspaces as part of your employee safety plan. If you want to have it as a standalone document, that's totally fine too. You want to make sure that you have it in writing and that you're prepared to tell the state, here's what we're doing to ensure physical distancing within our own workspace. Now, with that said, we've had a little bit of confusion over this from different folks. I do not want you to compromise existing code requirements in order to meet these physical distancing guidelines. And this is what I mean, right? Every building, whether you own it or you're in there as a lease, you're going to have different code requirements from the fire department, etc. I don't want you to throw those out the window so that you can otherwise comply with physical distancing requirements. For example, and this is a pretty simple concept, right? In order to fit more folks in your establishment, I do not want you to move a table in front of the fire exit, right? A lot of this is common sense, but understandably so, people are going to want to maximize the amount of folks that they can safely fit within their building, and totally understand that, and that's what we want as well. I just want to make sure that no one is compromising any independent code requirements that may be relative to your personal organization in order to otherwise meet these physical distancing guidelines, right? Because I think at the end of the day, the penalties for noncompliance with these codes are going to be more strict than potential penalties for not complying with physical distancing guidelines. Okay, the piece that I want to talk about here are revising and altering your existing employment policies. So we've talked about the fact that you need to have a sanitation plan in place. We've talked about needing an employee safety plan in place, and that includes accommodations to the workplace or reconfiguring social spaces, etc. The next piece of this I want to talk about that's really important are the employment policy piece of this, right? So these are things that are typically codified in a handbook, maybe a standalone policy, etc. If you don't have these policies anywhere, you need to really look at creating them. If you have existing policies with respect to workplace accommodations, telework, remote work, etc., you need to look at how this may potentially change those policies. And if so, can I change them, send out a new version, for example, of my employee handbook upon people coming back to work, so that they're aware of what the new policies are that are in place. So I want to run through just a few that I think are particularly important. I encourage everyone to thoroughly review their handbook on at least an annual basis. If you haven't done it in a while, I can promise you now is 100% the time to go back through and look at things that you can tweak or improve, etc. But with respect to a couple of different policies, I want people to pay specific attention to. One is your policies with respect to workplace accommodations. What's going to happen here is that there are going to be, and as we've talked about a little bit previously, there are going to be folks who say, I'm not safe coming back to work. Is there something that we can work out for me to continue to telework, etc.? I'm going to tell you that the safest way to do this from a legal liability perspective is to treat this as a reasonable accommodation process. Now, that's not to say that they otherwise are a qualifying employee under statute, entitled to reinstatement for some independent statutory reason. What I'm telling you is that as a practical matter, you should treat a request to stay at home or to telework as a request for reasonable accommodation. You should be interested in engaging in that interactive process to figure out if there is a way to meet the goals of both the organization and the employee. Okay, so what tweaks do I need to make to my accommodation policies to say, okay, if you don't feel safe coming into the office for some reason, here's who you can contact, and here's what we'll do in response, right? We're going to follow up with you. We're going to talk through it. We're going to figure out sort of collaboratively what are some things that we can do to help solve this, and it's going to be a case-by-case inquiry. That's really what you should be doing, right? What amendments on that same plane can I make to my telework policies, if any? The reality of it is some jobs, telework or the option for remote working, a barber shop, for example, that's not an available option. And that's totally fine. And under those circumstances, there's going to have to be probably a difficult conversation with the employee about the fact that, hey, we can't pay you just to sit home. If you're feeling unsafe coming in, perhaps an unpaid leave is an option. But in situations where people are allowed to telework and they can successfully perform their job duties from home, that is going to be the recommendation for the foreseeable future, is that you allow those folks to do that. Now, understandably so, many organizations are going to have concerns about, I don't think this person is being productive working from home. Totally fair concerns, right? So in that case, what policies do I need to put in place if that is a concern of mine to maybe add additional tangible requirements related to productivity? Maybe I'm checking in with that person more often to ensure that they're getting me the deliverables that they promised me, etc. There are modifications to job duties, job descriptions, all of that you can put in place in conjunction with these telework policies, right? But I guarantee that someone's telework policy, for the most part, that existed 3-4 months ago probably needs some modifications based upon the individual needs of your business and whatever job duties that your employees are doing on a day-to-day basis. So look at those things. A handful of other notes on these slides, right? And again, I encourage everyone to go through all of your employment policies, see where things may be applicable and you may need to make tweaks given this COVID-19 situation, and update those policies to the extent necessary. A couple of notices that people need to have up right now, right? So the Families First Coronavirus Response Act, which essentially does two things. It provides paid sick leave in certain situations that used to not be covered. For example, if I stay home with a child on the basis that they can't go to school or go to daycare, that's going to be a qualifying reason under both the expansion of FEMLA and under the paid sick leave provisions of the Families First Coronavirus Response Act. The federal government mandates that you have an FFCRA compliant poster up in your workplace. So when you open and The protections under the Families First Coronavirus Response Act are not going to sunset until the end of the year. And we will, of course, I say this hesitantly, but confidently, we will be able to open, right, at some time, hopefully in the near future. You're going to have this poster up somewhere conspicuous in the workplace. You can get it on the Department of Labor's website, easy Google search, type in FFCRA compliant poster, print that thing out, put it up in a conspicuous place in your workplace. Essentially what it does is it outlines the qualifying reasons for being able to take paid sick leave, and puts your employees on notice essentially of what their rights are. Think of it kind of as a Fair Labor Standards poster or a rest and meal break poster that you would otherwise have up in a break room, etc. I want to make sure you have that FFCRA poster up in a conspicuous place so that there are no issues there. Also, with respect to customer signs and signage, right? Do you want to put new signage up that alerts customers, for example, to the policies that you've put in place? So sanitation plan, for example, right? Do I want to have something, maybe it's nice and laminated, maybe I stick it on the window or what have you, that says, we appreciate your business. Here, we want to let you know, to our customers, here are the additional steps that we are taking to make sure that you feel safe and comfortable. A lot of times that's going to be like, we're mopping the floors at a greater rate than we used to. We're wiping down the countertops. We're doing X, Y, and Z. Whether or not you want to have signs up alerting customers to things that you're doing, and I think for the most part, it's a pretty good thing to do and a good recommendation. Okay, a couple of more practical matters, and these are things that really you need to do as part of the rehiring and onboarding process. And we're going to take some questions probably on this later as well. But one thing I want to make sure that people are aware of is any statutory obligations that they have with respect to hiring folks back and what we're calling this re-onboarding process, right? Re-onboarding in that we have employees that we may have had to terminate or let go, and all of a sudden 2 months later, we're bringing them back. What does that do for some of the statutory requirements or entitlements that employee, who's now not an employee, might have upon their return? So the first thing I want to put on your radar is the Form I-9, right? So the Form I-9 is the employee authorization document. It's a document that any employee in any industry needs to fill out in order to be authorized to work for you, right? It's the form where an employee presents one, proof of their identity, and two, proof of their authorization to work in the United States. Typically for a U.S. citizen, for example, that's going to be a passport because it's going to serve as both proof of identity and proof of work authorization. It may be a driver's license in conjunction with a social security card, etc. We're needing to prove those two things. But what I want you to know for purposes of this is that you're not probably going to need to fill out new Form I-9s for everyone. Here's the process that I want you to follow. Take out all of the Form I-9s for folks that you had upon termination or layoff, and go through there and look at who has filled out a Form I-9 within the last 3 years of their intended date of rehire. If they filled one out and it's been completed within the last 3 years, you do not need to fill out a new Form I-9 for them at all. All you do is go to Section 3. Section 3 on the Form I-9 is going to have a place for you to fill in the employee's name, their date of rehire. You sign and date it, you're done. If the employee is a longer-term employee, say they've been working for 8 or 9 years, and that 8 or 9 years ago was the last time they filled out a Form I-9, you're going to want to go through your entire process that you normally would for a new hire. That means getting proper proof of work authorization, proper proof of identity. Cleanest way to do it is just fill out a new Form I-9, put it in your pile, you're good to go. I would also just encourage people to take this as an opportunity to do a thorough review of your Form I-9s. There's a lot of little things on those forms that the USCIS considers to be technical violations. As a small example, if you put down a U.S. passport, for example, but you forget to check the box that says that the passport is from the United States, that could be a technical violation. And so in the event that you get a notice of inspection, which is an audit, essentially from the USCIS, they're going to be looking for those things. So long as you are taking the time to go back through your Form I-9s, this is also a good time to look out for some of those just small technical errors that you may have missed. And they're really, really easy to fix, right? For example, if I didn't check a box, all I got to do is check the box. I attach a piece of paper saying, this is the change I made on this date, and here's why. There was an oversight. I forgot to check the box. I sign, date it, attach it to the Form I-9. I'm good to go. To sick leave banks. And there's a lot of confusion around this, understandably so, because companies are allowed essentially to combine their vacation and sick leave policies. But they're really very different, right? There's no statute that mandates that an employer provide paid vacation for anyone, to whereas there is a statute in the state of Oregon, or several statutes really, that provide that employers need to provide a certain amount of sick leave per year, that the employee is entitled to payment for that time, right? So really there's a statutory obligation to accrue sick time and to allow an employee to take that for a qualifying reason, but there isn't that same requirement with respect to PTO. PTO is really based upon what your policy is. That's more like vacation time, right? So whatever your policy says is what your PTO policy is. Now, with respect to sick leave, it's different. That's protected time under statute. So here's what I want you to know for purposes of reinstating employees. And this is what the law says in Oregon. If you hire back an employee within 180 days of the time that they were separated, whether it be a termination or a layoff, you need to reinstate any accrued paid sick time that that person has under Oregon sick time laws at the same level that it was at upon separation. So if I had 3 days accrued under, say, 24 hours, for example, of available time under Oregon sick leave laws upon my layoff, when I come back, you hire me back now within that 180-day period, those 3 days need to be reinstated, and I'm eligible to take them for a qualifying purpose immediately. The only exception is if you chose upon that separation to pay out that time, which you're not required under statute to pay out that time, but if you did upon separation, as a gesture, for example, you're not required then to reinstate it. That time would just start over essentially and start reaccruing or front loading or whatever your individual policy is upon that rehire. But I want to make sure that people aren't getting in trouble with respect to sick time interference type claims because they're failing to reinstate those sick leave balances upon rehire. So if you are rehiring the person within 180 days, you need to reinstate that sick leave balance unless it was paid out upon separation. Okay, so this last piece before we get to a handful of questions that I think we have, what are some considerations around employee morale, rehire, and retention? One thing that we're really big on, I'm really big on, and Baron Liebman is as well, is not only following legal requirements, but making sure that we are the best employers that we can be, that we're treating our employees with respect and the respect that they deserve, frankly. And there's two reasons for that. One, it's the right thing to do. But two, employees who are happy, and this is just the reality of it, the better that you treat employees, the less the risk of legal liability. The people who ultimately sue employers are people who feel begrudged and angry and upset about the way that they were treated by employers. It is not hard to treat folks with dignity and respect, even in instances where you're handing out discipline or disagreeing with them, right? So I would take this or encourage you upon rehire, think of this as a fresh start. Maybe a lot of you already do this, but think about sort of what are some of the extra steps that I can take? And this really is all wrapped into this idea of how do I get employees to come back and feel safe, right? I want them to feel safe. I want them to feel appreciated and feel like they're coming back into an environment where their managers and the executives or whoever it may be really care about them, right? So those are some of just the morale and retention considerations because, again, it's the right thing to do. Two, it limits legal liability. And three, it really helps you retain long-term the folks that you want to retain. So those are some of the morale considerations, right? A couple of things to think about because I've been getting this question plain because I've been getting these questions a lot. What are some of the sort of creative ways that I can get employees who are currently on unemployment to come back? And to be honest with you, there's no one great definitive answer because the reality of it is, and to be honest with you, this was foreseen months ago when some of these laws were passed, was what do I do when an employee is making more on unemployment than they were working for me? What do I do? And I think the best that we can do, and this is with the note that some of these protections, the extra $600 a week, for example, are going to sunset at the end of July, so we're not going to have as many of these issues at that point. We're to reach out to employees and again, make them feel safe, make them feel comfortable, make them feel wanted in a sense that their input is being valued, okay? And making them want to come back to work. There's no good way really that we can think of aside from raising someone's pay up to a level higher than what they were making, which is just not economically feasible for a lot of people, to get folks to want to come back immediately. And it's a huge concern. And the best advice I can give on that point is to follow some of the guidelines that we've talked about today in terms of creating a plan that's solid, in terms of creating sanitation procedures that make people feel safe, make customers feel safe. But the biggest important part, in my opinion, of getting people to come back is to making them feel appreciated, making them feel valued, making them feel like they're a part of an organization that wants them to be there and wants them to succeed. That intrinsically, as part of human nature, is going to make people want to come back to work for you. So there's no great answer there, but I do just want to reiterate, these are things that are often overlooked in terms of human resources that are extremely, extremely important. What are the different things that I can do for my employees that are going to make them want to come back and are going to make them feel that they're safe and that they're valued? So we've covered quite a bit. I want to see if we have sort of any outstanding questions. Again, this is sort of a fluid situation, and at this point, we're trying to give sort of as best a guidance we can on some of these issues where there's just not a great definitive answer. But we'll take sort of any questions if there are any.
Thanks, Chris. We did get a couple of questions for you. The first question is, can an individual stay home and simply collect unemployment as opposed to coming back to work?
So that's a great question and one that we've been getting a lot. And the definitive answer, if the state employment department is following their own laws and own guidelines, is no, because this traditional idea of eligibility for unemployment, and as the law has always been written, is that you have to be actively seeking work, which is a requirement that has now been waived. But secondary to that, you're not supposed to be able to turn down work that is available to you. So technically, if you are offering work to someone and they're saying, no, I'm not going to come back, they theoretically, under the law, should not be able to therefore in turn collect unemployment, though I know a lot of people are going to do that, or at least attempt to do that, and we don't know definitively how the employment department is going to treat those claims. There's a lot of stuff going through there right now. It's quite possible they may miss applications that are coming in, but the number one thing that you can do as an employer is to be honest on these unemployment applications, right? So if it's asking you, or if someone from the unemployment department calls you and say, hey, did you offer this person work? And you did, of course, tell them, yeah, because we want to be forthright and honest. And at the end of the day, it's the employment department's decision of whether or not that person's eligible or not. But we want to tell the truth. And theoretically, no, someone should not be able to just choose not to come back to work indefinitely and indefinitely collect unemployment.
Thank you. Do I have to bring back every employee that I terminated or laid off?
No, you don't. So this may come, I guess, as welcome news to some people who may have employees that they otherwise wanted to let go before this whole thing, just to be completely honest. Absent some independent right to reinstatement, you do not have a duty to bring back folks that you laid off. And when I say independent statutory duty, I'm talking about if that person was already on some sort of FEMA leave, or they have a disability, or they have something else that otherwise gives rise to a right to reinstate them, you don't have a right to, or a duty, excuse me, to rehire anyone. In fact, I would guess that a large amount of people are picking within a group of certain folks and hiring them back. One thing I would note on that, though, is to make sure that you're not making rehire decisions, same as if you were hiring in the first place, and none of this would have ever happened, in a way that's discriminatory, right? If you have 60 workers that you're considering hiring back, and then you hire back 30 of them, and those 30 were the youngest out of that entire group, that doesn't look so great, right? You might have independent reasons for bringing them back, but you want to make sure that you're making decisions fairly, following your hiring, rehiring practices, and not making decisions about who to rehire in a manner that otherwise appears to be discriminatory. But at the end of the day, do I have to bring back everyone that I laid off? No.
Thank you. What are my options for reducing employees' hours upon rehire?
That's another good question, and I think this is going to come up a lot, particularly if some of these industry-specific guidelines come back and say that, hey, we can only have 50% of our normal capacity in this restaurant at a given time. We may have situations where that person's hours need to be reduced. You can reduce the hours, right? Especially when you're rehiring them, right? So if I had an employee that is an existing employee and I'm cutting their hours, I'd be a little bit more worried about, okay, is that looked at as an unlawful or adverse employment action? You probably have a good independent reason. So the answer at the end of the day is probably not. But when you're bringing them back, you have a little more discretion or leeway to say, hey, here are the hours that we have for you. The good news that I think for both employers and employees is that Oregon has what's called this work share program, where essentially if you're reducing an employee's hours by a certain amount, unemployment will step in through work share and help to subsidize some of that, right? So if I'm cutting someone's hours from 30 in a week to 22, that person, in conjunction with the employer is actually the one that has to apply for it, can get on this work share program where unemployment will theoretically, I always say theoretically because I know a lot of these claims are not being processed right now in a timely manner, will step in and help to subsidize some but not all of the reduction in hours with additional wages. So I would encourage folks, if they haven't already, to check out Oregon's work share program. It's something that not a lot of people knew existed before a few months ago.
Great, thank you. Do I have to provide personal protective equipment for my employees?
So that's a good question, and really the answer is rooted in OSHA and OSHA's interpretation and guidance on the issue. So essentially the standard is employers are required to perform what they call a threat assessment or an individual sort of workplace hazard assessment, right? To determine if there are hazards in the work environment that would necessitate the use of personal protective equipment, PPE. So it's going to be sort of an individual inquiry for each business. If you're on a farm or in a farming setting, for example, you very well may not need personal protective equipment because it's just not necessary under the circumstances because you're out in open air, you're not in frequent, contact with customers, etc. But if in looking at your individual business, you determine that there's a reasonable probability that an injury or an illness could occur if you did not provide PPE, then there is a duty to provide that PPE. So the first step really is to make this threat analysis and inquiry as to, based upon the nature of my business and my retail store and my restaurant, etc., Do I have to provide PPE, or do I think that really it's the safer route to go under the circumstances? And that also, I should mention, there's going to be some requirements in this industry specific guidance that we've talked about, right? That may necessitate that employees wear PPE, restaurants, for example, right? So in those circumstances, yes, you as the employer should be providing that PPE for the employee. Now, if you make a determination based upon the business that there is no reasonable sort of probability that an illness will occur based upon the nature of your business, then no, there would be no duty under that particular circumstance to provide PPE. But as a general idea, should you have it maybe available if you're able to afford masks, or if employees want to bring cloth masks, etc., I think it's a good idea, and it's going to go to some of what we've talked about in terms of making employees feel safe and comfortable coming back into the workplace.
Thank you. Last question. What do I do if an employee is violating our social distancing safety protocols or taking off their mask or gloves if it's a workplace requirement?
Mm-hmm. That's another really good question. And what it's going to come down to is your policy, right? So we've talked a lot about sort of written policies that need to be updated in order to sort of transition to this new normal workplace setting, right? And so part of that, of course, could be that we're requiring folks in the building or in our office space or wherever it may be to wear personal protective equipment, masks, for example, right? Whether that be cloth masks, N95 masks, whatever you may be requiring under the circumstances that your employees utilize, right? If there's someone who is just not adhering to those guidelines, then they're not adhering to your your performance standards as an employer. But what I would say is you need to make sure that you write into the policy that failure to adhere to the guidelines and the safety, guidelines that you put in place could lead to discipline up to and including termination. So employees are absolutely going to be subject to discipline if they're not following workplace guidelines with respect to safety. If someone's running around, taking their mask off, making people feel unsafe and uncomfortable, that's an issue. And puts other people at risk in something that we really just don't want. And so step one, let's make sure we have a good policy in place with respect to our sanitation and our safety plan. And somewhere in there, we're going to want, hey, failure to adhere to these guidelines with respect to our safety expectations could subject you as the employee to discipline up to and including termination.
Thank you. That's the last of the questions we had. I want to draw the viewers' attention over to our web links on the right-hand side. This webinar is the first of several HR-related resources available to SAFE policyholders. So if you're not already signed up for the SAFE Learning Center, the registration information is in the web links pod on the right-hand side. The SAFE Learning Center has a wide variety of safety and health content, and will soon have more HR content, so stay tuned. We also included some Baron Liebman COVID-19 resources as well on the right-hand side. Chris, you also provided a reopening checklist for employers.
Yes.
So that's available for download.
Should be available for download there. And again, the checklist, what it's going to do for you is sort of just outline some of the different bullet points that we've talked about today. So consulting state and federal guidance with respect to the legality of reopening, Form I-9 compliance, sick leave reinstatement, sanitation and employee safety plans. All of that is going to be in a nice checklist for you that you'll have access to, that you can print, and I'd encourage you, of course, to use it to the extent that you can in formulating your own internal policies.
Thanks, Chris. We really appreciate your time. Thanks for watching this presentation to our audience. I hope everybody has a great day.